Ladies and gentlemen, good evening to you here, and greetings to all those on the internet, whatever time zone you're in. I'm Michael Schneider, one of the founders of LaLive and the senior partner there now. LaLive, that is organizing this event tonight in partnership with the Graduate Institute of International Studies and Development Studies. With Professor Krisch, we agreed that I would give a short introduction to the context of this LaLive lecture, and then he will present our distinguished guest tonight. The concept of the LaLive lecture initiated in the cooperation with the Graduate Institute on the one hand, and the LaLive brothers and the firm they created, Jean-Florian LaLive and Pierre LaLive, who were both alumni of this institution. The concept of the lecture has two important aspects and objectives of both institutions. It's the interface, the interrelationship between different aspects of our work, the interface between public international law and private international law, the interface between research and teaching on the one hand, and the practical application in international relations, and the interface between those who prepare a case as counsel and those who decide it as arbitrator or judges. Now, this interface or interrelationship link between academia and the practice is obvious at the Institute. I need not emphasize the outstanding academic reputation of the Institute, in particular in the field of international law, headed by Professor Krisch, and the distinguished faculty members and their also practical implication. I mention the close link of the Institute with the practice of international law. Some of the professors are acting as counsel or in other functions in international fora, including the International Court of Justice, but also the relationship created by the executive program, the distinguished fellows of the Institute, the institution's alumni, and the MITs, to which I will return in a moment. On the other side of this partnership, there are two international lawyers, one in the combination of the practice of law and the research and teaching, in particular in the relationship between public and private international law. The elder one, Dr. Jean-Florian LaLive, is known as a well-reputed international practitioner of arbitration. He also played a major role in the support for refugees during the Second World War, and then in the Middle East with UNRWA in Beirut, with human rights and the rule of law, with in the Secretary General of the International Commission of Jurists, and as first secretary of the ICJ in The Hague. He also lectured there and had many other practical aspects. His brother, Professor Pierre LaLive, is, of course, well known at this institute, not only as alumnus, but also as teaching here, where he introduced the course on seminar on international commercial transactions as part of the private international part of the curriculum. He is an emblematic figure in international arbitration, both as in his practice and in his writings. Both of them, as I mentioned, are graduates from the Institute and kept close relations. And this is also true for the law firms they created and which bears their name. In this law firm, we preserve and cherish the tradition of precisely working in cases with academic background, in academic input, in the cases we defend, in the way we practice law, the legal writings, also in the support of Cluny, and traineeship, and this is one of our special links with the Institute, the MIDS interns of whom I see a number here tonight, who are a regular practice of our firm in supporting the work of the Institute, especially through the MIDS. From the start of this series of lectures, some 17 years ago, this combination of public and private international law was emphasized. The first lecturer here was Judge Rosalind Higgins, president at the time of the ICJ, and the subject of her lecture was the International Court of Justice and private international law thoughts, a very interesting perspective on the activity of the court. And that was followed by many distinguished lawyers, distinguished speakers at this Lalive lecture. Their courses are published at the ICSID review, and tonight we have another highlight in this list of Lalive lecturers, and Professor Krish will introduce him.
Thank you, Michael. It's our great pleasure to continue the series of joint ventures in the Lalive lectures that we've now carried on for quite a few years with really, as you've highlighted, splendid speakers, and today obviously is no exception at all. Over the years, we've invited many outstanding academics and practitioners to this lecture, and Philippe is clearly both an academic and a practitioner, and of course also outstanding. He's a professor, as it says here, at University College London, a visiting professor at Harvard Law School, and he's made important contributions to the academic understanding of international law, especially in the area of international courts, in the area of international environmental law. Now, he's also a barrister, a King's Counsel, co-founder of Matrix Chambers, and practicing now at 11 King's Bench Walk. And he has appeared in many consequential cases, far more than I can list. And generally, I could keep spending this hour kind of talking about his achievements, but I think we'd rather let him speak. So I just limit myself to a few. For me, the most formative was probably his involvement in the Pinochet case. Initially, there was still a student. But he was also more recently counsel for Mauritius in the Chagos proceedings, and perhaps for today's audience, his appearance for Palestine and the proceedings leading up to the advisory opinion earlier this year was most visible. Now, he's exceptional in many ways through his practice and in his academic contributions, and also because somehow kind of he uses international law in his practice for worthy purposes, not just the practitioner full stop, but the practitioner of the law for causes. But what's perhaps even more remarkable is that he manages to combine this practice and academic work with writing amazingly beautifully. So he's maybe more than anybody else. He's been able to write books about international law, or kind of about international law, for a general audience that people really love to read. I admired, back in the day, Lawless World, which I found was in many ways eye-opening, and I used to teach with it. Many of you will know East-West Street on genocide, crimes against humanity, a book that has won a whole series of prizes. You may also remember The Last Colony, just a couple of years ago, which is precisely about Chagos, and of course draws also on his kind of very close involvement. So I think it's pretty fair to say that there's nobody else around who can write so lucidly and interestingly about international law as Philippe Sands, and perhaps one can say he's really as close as it gets to being a rock star of the discipline. Now, I don't want to burden you with too many expectations, also because many people will think that the topic of today's lecture, investor-state arbitration, doesn't precisely rock. Well, I mean, many of us actually might think it does, but But when I see the rest of the title, Discomforts, kind of a personal journey, I pretty much know that Philippe's storytelling abilities will come to shine and take us into territory of investor-state arbitration in a way that we normally kind of don't discover. Thank you so much, and please join me in welcoming Philippe Sands.
Thank you, Nico and Michael, for that very generous, overly generous, and worrisomely generous introduction. My wife always says, have low expectations. It's always best. I'm really grateful to have been invited to give this lecture. I have a long-standing relationship with LaLive and with the Graduate Institute, and so it's particularly special and lovely to be here. These are two institutions that I admire greatly, and I'm very pleased to be associated with both. In fact, I spent a little time with the LaLive brothers very early in my career, and from them I picked up a sense of their fundamental respect for ideas, for the notion of an independent spirit, and for a sense of public service. And it is in this spirit that I have thought carefully about what I might talk about today. I could, of course, have discussed a myriad of rather technical, legal, or institutional issues that arise these days in the field of investor-state arbitration, but I'm not going to do that, at least not directly. What I've opted to do instead, at a time when international law is under serial and serious attack, is to offer some more personal reflections in a constructive spirit. My journey into the world of investor-state arbitration began in 1984. I was hired by Eli Lauterpacht to work with him on an academic project at Cambridge University on disputes about state contracts. I was the first research fellow at the new, what is today the Lauterpacht Center for International Law. I was 23 years old, and I was totally unencumbered by any knowledge or ideas whatsoever about state contracts. I had precisely zero experience. During my LLM, we had occasionally encountered a case or two about nationalization or expropriation or some other allegation of undue interference. But it's hard to imagine, back in those days, the Permanent Court of Arbitration had precisely zero cases, and the International Center for the Settlement of Investment Disputes had, I think, 2 cases. Eli introduced me to the Delagoa Bay Railway arbitration. This was a late 19th century case, a claim brought by the US and the UK against Portugal following the seizure of a railway in Mozambique, a Portuguese colony. At the time, as it was explained to me, it was a case about compensation. But today, and with the benefit of hindsight, I now see that we would look at it in a very different light. It was really about 3 colonial powers fighting over a railway in Africa with no regard whatsoever to the interests of the local population. A dispute that was seen as essentially private and commercial in nature, totally presented as being disconnected from matters of public policy or matters of justice. Eli insisted that I qualify at the English bar, even as I developed some sort of an academic career. I joined Middle Temple. I got a pupillage at 2 Hare Court. This was a real age of innocence for me. My very first brief ever as a barrister was a hand-me-down from Sir Ian Sinclair, who had recently retired as the legal advisor at the Foreign and Commonwealth Office. The case concerned a claim brought by an investor in a cancelled tourist project, and the arbitral tribunal's jurisdiction was based on an ICSID provision under national local law rather than a bilateral investment treaty. The case was called Southern Pacific Properties versus Egypt, and it was literally the first case I ever did. I had, I think it's fair to say, a rather peripheral role, fleeting in time and input, advising the claimant on some obscure point on the effect of treaties under the law of Hong Kong. 3 days in Paris at the age of 26 were incredibly exciting, and the idea that you were paid to do it was even more exciting. But the point is, it introduced me to the world of ICSID. That case is often relied on and cited on the law applicable to the quantification of damages. But I mainly remember the experience not for that issue, but for the character of the individuals that I met in the course of those proceedings. And not least, a very delightful Dutch gentleman who was introduced to me as the founder of the ICSID Convention. He was called Aaron Brokers, a Dutch legal scholar known as Ronnie, part of that generation that included Hirsch Lauterpacht and Raphael Lemkin, the men of whom I wrote in the book that Nico mentioned, East-West Street. These were all individuals who emerged from the ashes of the Second World War, imbued with a belief that law, and international law in particular, could enhance the human condition. Ronnie Brokers believed in rules on investor-state arbitration, just as Lauterpacht and Lemkin believed in rules on crimes against humanity and genocide. In fact, there were many points of interconnection on these characters, not least Hartley Shawcross, whose speeches at Nuremberg had been written by Lauterpacht and with whom Aaron Brokers then worked on the drafting of the ICSID Convention with Herman Abs of Deutsche Bank. The Ronnie Brokers that I met was a man who was plainly motivated by instincts and principles of public service and the public good. He had no interest in commercial engagement or personal advancement or personal profit. Those values which I encountered at that early stage in my career have inspired my own approach. A few years passed. One day, my office at the School of Oriental and African Studies, where I then was, a former student of mine called me out of the blue, Stephen Hodgson. He had been engaged as a consultant by the Ministry of Agriculture in Albania. He worked in Tirana in an office which had a locked cupboard. In an unguarded moment, he finally managed to gain access to the locked cupboard. In the cupboard, he discovered 23 packages sent by Federal Express by Mr. Ibrahim Shihata, the Secretary General of ICSID, to the government of Albania, informing them that they had been sued under the ICSID Convention. It was their first case, really, since the Corfu Channel case in 1949. They were sued by a Greek company that had invested in a melon farm, Mr. Shihata informed them. Now, this was a moment when the country was emerging from decades of despotic rule, and if you want to get a sense of what that meant in practice, I recommend that you read Ismail Kaderay's wonderful novel, Broken April. It is, I tell my students always, incredibly important to read literature alongside the legal documents you write to get a sense of what it is you're working on. The 23rd Federal Express package, once opened, they were all unopened, apart from the first one when they all disappeared, explained that in the absence of any response from Tirana, an arbitral tribunal had already been constituted, and a directions hearing would be held in Frankfurt in 2 weeks' time. "Will you go?" Stephen Hodgson said to me. I said, sure, I can go. And I did go, and apparently performed well enough at that directions hearing to then be retained by Albania for what was, as I said, its first international outing since the Corfu Channel case in 1949, actually the first ever case at the International Court of Justice. It was a pretty strong tribunal, Karl-Heinz Buchstiegel, Andrea Giardina, and then a gentleman called Fred Fielding, on whom there was much excitement because it turned out he had been Ronald Reagan's White House counsel. So the case was called Tradex Hellas versus Albania, essentially my second ICSID case. I thought I needed assistance, so I brought in 2 juniors. One was Ruth Mackenzie, who was a colleague of mine at the School of Oriental and African Studies, and the other was an Australian friend called James Crawford, who had recently moved to Cambridge. This was his first ever ICSID case. James and I went to Tirana. We were put up in one of the many houses of the recently deposed dictator, Enver Hoxha, and it was a place that we particularly enjoyed for its vast bathrooms and total absence of any running water for the 3 days that we spent there. I mean, anyone who's travelled with James will understand how much he enjoyed those kinds of things. We also loved the indoor pond in the entrance hall, vast, populated by a huge number of small yellow rubber ducks. But over those days, the use of toilets was difficult and the use of a shower was impossible. Albania won the case on the merits. Our secretary of our tribunal, with whom I'm still in touch, a wonderful person, Margareta Stevens, told us that it was the first time in the history of ICSID that the respondent had won a case by a unanimous decision. It may also have been the cheapest case ever in the history of ICSID. The total fee for the respondent's lawyers, jurisdiction phase, merits phase, 4 rounds of written pleadings, 2 rounds of oral hearings, was £75,000. That was the total split between the 3 of us, and we won 100%. Keep that figure in mind. Having been involved in now 2 ICSID cases, I was now a leading world expert. Investor-state arbitration became part of my practice as counsel at the bar, alongside very occasional cases before the English courts and a small number of interstate cases before international courts and tribunals. And I acted both for claimants and respondents, something that I've always appreciated because you learn very different things working in those ways. In fact, my last case as counsel for 2 claimants against Mexico concerned an investment in a national car registry in Mexico City that was abruptly terminated when it emerged that the claimant's principal employee was an Argentine gentleman who was wanted for mass murder, disappearances, crimes against humanity, and torture during the Argentine dictatorship. So there are points of connection between these apparently disparate areas of practice. I did dozens and dozens of cases as counsel. That line of work ended in 2007 when I accepted a first appointment as arbitrator. I had by then already formed the view, which I still hold today, that it was inherently problematic for the same person to act both as arbitrator and counsel in investor-state cases. This is because essentially, as we frankly all know, essentially the same legal issues arise in all cases. Is it an expropriation? Is it unfair and equitable treatment? And so on. And any reasonable observer finds it frankly impossible to understand how the same person does not face a conflict if they spend the morning working as counsel making arguments on whether an expropriation has or has not happened, and then they spend the same afternoon drafting an award on the definition of expropriation. Double hatting is completely untenable. It totally undermines the legitimacy of the system, period. My first case as arbitrator was Bivac versus Paraguay. It concerned a contract for the provision of services of an inspection of imports into Paraguay. The claimant submitted that by failing to pay a number of outstanding contract invoices, it had breached provisions of the Netherlands-Paraguay BIT on expropriation, fair and equitable treatment, and something that I encountered then, as many of you have, a thing called an umbrella clause. I was appointed by Paraguay. I sat with Yves Fortier and Rolf Knieper, 2 terrific arbitrators. The significance of the case lay primarily in a jurisdictional objection relating to the nature and effect of an umbrella clause. Each contracting party shall observe any obligation it may have entered into with regard to investments of nationals of the other contracting party, said the BIT. And such clauses have long been a source of difficulty for parties and for arbitrators and commentators. The situation may be further complicated when the contract at issue, as in this case, contains an exclusive jurisdiction agreement in favour of the domestic courts. And the tribunal in the BIVAC case ultimately decided that it had jurisdiction to hear the claim for breach of the umbrella clause, as that provision would otherwise be given no meaningful effect. But it also ruled, unanimously on all aspects, that the exclusive jurisdiction clause must be observed to the extent that it was applicable in favour of the courts of Paraguay, given that the fundamental basis of the claim was characterised by the arbitrators, us, as breach of contract. In fact, the claims other than those relating to the umbrella clause were ultimately settled, so there never was an award on the merits. I have to say that that first experience as an arbitrator was absolutely genial. Deliberations were collegial, completely open-minded, and the decisions ended up being unanimous. And I experienced for the first time that special process, very privileged process, of deliberation. The testing and the probing of each arbitrator's views and instincts and perceptions as the collective, the group, embarked on a search for consensus. Really, as a first arbitral experience, I could not have asked for more on how an arbitral tribunal ought to function, and in particular on the significance of personal chemistry in the deliberative process and the role played by the Secretariat. My experience with successive secretariats at ICSID and the PCA and other places has just been outstanding. They are just simply outstanding at what they do. It could be said that, in a sense, BIVAC was a sort of rite of passage, introducing me into an age of experience. And over the next years, decade and more, I sat on dozens of cases that involved a great number of different issues and countries from across the globe. It was almost always a positive experience and almost invariably reflecting a genuine desire to find a consensual approach. But I have to say from the outset, there were aspects that started to trouble me about my new community as an arbitrator. Why were so few women appointed? In fact, it was only in 2019, after 12 years, for the first time that I sat with a female arbitrator. Why were no black arbitrators appointed? Why was I sitting with colleagues who continued to act as counsel or experts in other arbitration cases, and whom, as I saw, faced very directly situations which reasonable people would consider gives rise to a straight conflict? And why was the community of arbitrators drawn from so narrow a pool of lawyers? As the years passed, almost imperceptibly, indeed so gradually that I didn't really notice it at first, changes occurred in the system. The proceedings became longer and ever more tortuous. The pleadings became longer and ever more tortuous, and very often, to speak frankly, terribly drafted. Discovery emerged. It didn't exist in the early days. The legal teams that turned up sometimes got larger and larger. Cross-examination and other lawyering was often of a standard that I had not encountered in any of the other international courts and proceedings I had come across in terms of its poor quality, how cross-examination in particular was conducted. And there was a shift of ethos as investor-state arbitration ceased to be a system intended to promote direct foreign investment concerned with the well-being of people and countries, and to develop a rule of law ethic, and to resolve disputes where public authorities had truly, in the old sense, abused their powers. Money came into the system in huge amounts. And with the influx of bigger and bigger bucks, the character of the system was transformed. Jurisdiction was broadened, for example, with decisions on MFN clauses. Definitions of expropriation and fair and equitable treatment were increasingly expanded. The range of governmental actions that were subject to challenge grew and grew and grew. And it was as though the whole thing had become a business, an industry, a source of lucrative employment for my students and a profitable business for arbitrators, including myself, lawyers and experts, and for the panoply of publishers and conference organizers that seems to have grown up, and for the funders who are now proliferating. It was as though investor-state arbitration came to be seen as a broader means of clamping down on legitimate exercises of public power for the broader social good. And as this happened, I sensed that the nature of collegiality amongst the arbitrators began to change. Imperceptibly, I realize now, looking back, I entered an age of discontent or discomfort, accompanied by increasing questions put to me by observers. Does the system fulfill its original objectives? Does it deliver just outcomes in a timely and cost-efficient manner? Does it protect the full range of legitimate interests that are in play for all parties, whether they be economic, social, political, or other? Is it a system that is broadly recognized to have legitimacy? And, to put it personally, is it a system I want to continue to be a part of? These and other questions have come to the fore, by way of example, in a series of cases that relate to the environment. Nico mentioned I've been involved in the environment for a long time, and related issues of public participation. I recognize that the protection of the environment is a recent matter and that it has a generational aspect. At law school in the early 1980s, the environment did not feature at all. My own introduction to the subject was completely accidental. The events at the Chernobyl nuclear power plant in April 1986 in Ukraine. My first academic book was on Chernobyl. I think it sold about 102 copies. If it was more than that, I'd be amazed. My second one was a treatise on principles of international environmental law. And that book, and the earlier one actually, did cause me to become involved in international environmental litigation, both at the national and international levels. And I got to participate in negotiations on this growing field of environmental protection, including the 1992 UN Framework Convention on Climate Change, which I helped to negotiate, and the 1992 Rio Conference on Environment and Development. And as I became involved, I read myself in more and more on matters of environmental concern. This was around the time, actually, of the Tradex case. James was always very strongly supportive of opening this door to my line of work and supportive of my increasing sensitization to this aspect. Books like Rachel Carson's Silent Spring, published in 1962, and articles like Christopher Stone's Should Trees Have Standing, published in 1972, and I still call it the single best law review article I have ever read in my whole life. Here is a lawyer who can actually write, a rare thing. These were the kinds of things that I read that sensitized me as my sort of double life was coming into being. In the meantime, as our environmental crises became ever more grave, I have come to believe that the protection of the environment is the defining challenge of our times, one which, across the next generation, will make the current horrors of Russia and Ukraine, Sudan, Israel and Palestine pale into relative nothingness. If you descend into the science on what is coming, it is absolutely shocking, and you need to descend into the science of what is coming. Climate change threatens the very existence of some states and is already having catastrophic consequences for communities around the world. We know that exploitation puts huge strains on delicate and finite resources. that it poses particular threats to the life and traditions of indigenous communities and to biodiversity, and that environmental harm is very often, in human terms, irreversible. Faced with these environmental challenges, states and public authorities face extraordinarily difficult trade-offs in balancing the protection of the environment against other important social and economic needs. And so what I'm saying is that my work as an academic and as counsel has made me particularly aware of the need to ensure that environmental and related considerations are given due weight if and as required by the law that is applicable in a particular case. But it has become blindingly obvious that many of the arbitrators that I sit with on investor-state cases seem very ill at ease or even unwilling to recognize these environmental realities, and in particular, to understand the real challenges and difficulties they pose for public authorities who are charged with engaging in this act of balancing. Bear Creek versus Peru was probably the first case that alerted me to these difficulties. It concerned a mining project which generated strong objections from the community of indigenous peoples who lived around it. I joined in a consensual award, finding that a violation of international law had taken place. But I also felt it necessary to dissent in limited part, something I think I had very rarely, if ever, done up until that point. Because I found, on the basis of what I thought to be compelling testimony and expert evidence, as I wrote in my partial dissent, that the complainant had been partly complicit in the events that led to the loss it had suffered. This was because, as I wrote, it, in my view, failed to consult at all or properly with the indigenous communities as the applicable ILO Convention on Indigenous Rights, which was applicable, required it to do. I was alone in concluding that this failure was contributory to the loss suffered and that it had an effect on reducing the quantum of damages. Two more cases followed, Opera Fund and Renergy, both against Spain. These were amongst the very large number of cases challenging Spain's efforts to rein in the cost of its program to promote renewable energies. My colleagues in both cases, in the majority, I dissented on both, found that Spain had violated its obligations under the Energy Charter Treaty to provide a stable rate of return. I dissented in both cases. This is what I wrote. The expectation of a relative or absolutely immutable rate of return identified by the majority is not supported by the evidence or the case law. It was not legitimate and it was not reasonable. The context of these cases, as many of you will know, was a very grave financial crisis of 2008, coupled with a collapse, a drop in the price of renewable technologies. In that context, I expressed the concern that the approach taken by the majority would, and I quote, foster a greater distrust in the system of investor-state arbitration, which was seen increasingly in some quarters, and this is what I wrote, as favouring the interests of lawyers and arbitrators and banks and those working in the financial services sector, but not many others and not the public good. I worried that the approach of the majority in those cases set in soft stone, a regulatory framework that must necessarily be allowed to change in the face of technological changes that reduce reliance upon greenhouse gas emitting fossil fuels, and that the majority approach would undermine efforts to allow states to take actions necessary to address the serious threat of global warming and climate change, and that by making certain technologies more expensive, the Energy Charter Treaty would be seen as, and I quote, obsolescent rules that reflect a bygone era, a legal carbuncle negotiated in an earlier age that will limit efforts truly to transform energy supply systems and offer protection to our common environment, end of quote. I had other concerns. In Opera Fund, for example, I expressed a concern about a potential conflict where the claimant's law firm defended its own legal opinions given to a lending bank in the context of the investor's original due diligence. I wrote, and I quote, "The revolving door that seemed to operate in this case between the bank that lent on the one hand and the investors that borrowed on the other will hardly enhance public perceptions as to the legitimacy of the system of investor-state arbitration," end of quote. Now, in this series of cases, the Energy Charter Treaty cases involving Spain, I have not been alone in expressing views. And in due course, as you are, many of you, well aware, and I certainly don't want to wish to suggest cause and effect or take any credit, member states have started withdrawing from the Energy Charter Treaty for exactly these reasons. In other words, the warning signs were absolutely clear. Around the same time, I sat in several cases that concerned mining in the Páramos of Colombia. A páramo is a high-altitude tropical region above the timberline, which is very rich in diversity and of huge significance in storing and protecting finite freshwater supplies. The first award that was handed down was in a case called Eco Oro versus Colombia. In its award of the 9th of September 2021, the majority found a violation of the minimum standard of treatment, where the state went back and forth in its environmental regulations, ultimately banning such mining, even where exploration licenses had already been granted. I dissented from the majority, and I quote, "By any reasonable standard, the situation faced by the respondent in seeking to give effect to the legitimate objective of environmental protection was challenging. Its approach in meeting that challenge was not perfect, but it was not contrary to the rule of law, and it was not conduct that shocked or offended a sense of judicial propriety. The Canada-Colombia Free Trade Agreement had in fact gone out of its way to carve out legitimate actions to protect the environment, and the protection of the Páramos was recognized by all three arbitrators as legitimate. What the award left to a later stage was the question of quantum. I then sat in a second case, Red Eagle versus Colombia, which raised essentially the same issues in essentially the same part of the world. That award came down in February 2024, so about 2.5 years later. And this time there'd been a shift, and I was in the majority. What changed was the position of the president, who supported the views I had expressed in the earlier arbitration. And the majority ruled that Colombia's decision to ban mining in a Páramos area was taken in good faith and did not breach the minimum standard of treatment or amount to an unlawful expropriation. 4 months later, on the 7th of June 2024, a third tribunal dealing again with essentially the same issues, Montauk Metals versus Colombia, in which I did not sit, reached essentially the same conclusion as I had set out in the original dissent in Eco Oro, and which the majority had found in Red Eagle. But what was striking about Montauk Metals versus Colombia was that that decision was unanimous. So you see the shift over time in the decision-making, but also the sense of lottery as to what the outcome is going to be. The one aspect that remained was the quantum award in Eco Oro, and that decision came down a month after Montauk Metals versus Colombia on the 15th of July of this year, so quite recently. This was the second ruling of the same tribunal, but this time I found myself in the majority on an issue which essentially raised a rather simple question. What is the value of the right to apply for an environmental permit that is definitely going to be refused? the majority ruled that having failed to demonstrate any loss, no award would be made for damages suffered. Now, this series of cases has, to be honest, troubled me. Vast amounts of time and money have been expended on these litigations over many years. And for what purpose? The award in Bear Creek produced a most modest quantum award. The award in Renergy gave a slightly greater sum, but with reasoning of a kind which, I think it's reasonable to say, contributed to the dismantling and ending of the Energy Charter Treaty arrangements. As to the 3 cases on the Colombian Paramos, they produced precisely nothing for any of the complainants. So it could be said that the system is sort of working. But is it? Seen from the bench, I would say there are a number of warning signs that might be needed, and here that might be heeded. And here I'm being illustrative, not complete. The first is the issue of costs. In some cases on which I sit, these are indeed maintained at a very reasonable level. But increasingly, there has been, at least in the cases on which I have sat, an absolutely striking escalation. And the fees are now sometimes utterly astronomical. A 2021 study reported on mean legal costs of a single investor-state arbitration. For claimants, it's about $6.5 million, and for respondents, it's about $4.5 million. In Echo Oro, one of the Paramos cases in which I dissented and felt compelled to express a view, I wrote a declaration on costs. This noted that the respondent's costs was $6.3 million. I wrote, and I quote, "The claimant, on the other hand, has incurred total costs of just under $33.3 million. I'm reading now what I wrote in the declaration. This is, by any reasonable standard, a jaw-dropping figure. In the context of facts and an environmental context which ought to have caused any reasonable lawyer to alert the claimant to the serious risk of failure, the amount is indecent. Having been involved as counsel in dozens of investor-state cases and an equal number as counsel in interstate cases at the International Court of Justice and other international courts and tribunals, often involving matters of far greater complexity, but being litigated at a far lower cost, I have trouble understanding how it is possible to rack up such legal costs." End of quote. And I also felt compelled to address one element of the bill of costs, namely the costs incurred in retaining the assistance of a quantum expert, Compass Lexicon, to produce 2 reports. One was 88 pages long, the other was 70 pages long, and they were examined at the hearing for no more than 1 day. That cost $2.9 million, a figure that is beyond my comprehension. The expert valued the claimant's loss at $696 million, but, as I wrote in my declaration on costs, failed to answer a question put by the tribunal to both parties, and I quote, "How can Echo Oro's loss of opportunity to apply for an environmental license to allow exploitation be valued? On what basis is the quantum of that loss, if any, to be assessed?" End of quote. And then I wrote in my declaration, and I quote, "For $2.8 million, it is not unreasonable for a tribunal to expect to receive an answer to the question. Indeed, the failure to provide the tribunal with an answer to this question made its task more difficult and contributed to the length of the quantum phase." End of quote. In the end, of course, the claimant got 0 in damages, and both parties were ordered to cover their own costs. This conflictual approach in which each side puts forward evidence on its quantum arguments, one very high, the other much lower, and the tribunal then decides, is, to speak frankly, not helpful at all. It is costly, it is time-consuming, both in financial terms and, to speak frankly, on the mental health and well-being of arbitrators. There are other approaches. For example, in the recent case of LSG Building versus Romania, the parties' quantum experts worked together to produce a joint damages model, one that highlighted areas of agreement and disagreement together with reasons. Practices like this should be encouraged, but very often they are not, for reasons essentially of arbitral deference, a point I will come back to. Now, of course, a party is free to spend as much as it wishes on legal representation, but can it expect a claim for such extraordinarily inflated legal fees and costs to pass without comment or reaction? A reasonable observer might ask, are such fees and costs proportionate to the significance or complexity of the issues at stake? Are they truly reflective of the nature or quality of the work that has been done, or really actually needs to be done? How many lawyers does it take to change a light bulb? The joke often goes. Having been involved in these investment arbitration cases on both sides, I am acutely conscious of what is actually needed on the facts and on the law, and that such costs, in my experience, have never been needed or justifiable. As someone who serves as counsel in interstate disputes, I'm completely aware of the fact that such cases raise issues that are more complex, more novel, and far, far more significant. Yet the costs incurred in those cases pale into nothingness in comparison to these kinds of costs. Something has gone terribly wrong in ramping up costs in so many cases. Often it's the consequence of procedural decisions that add delay and further time and cost. Now, there are many reasons why costs escalate, but let me just mention one example, and reasonable people can disagree on this. The post-hearing brief. This creature may, of course, be useful where a discrete question has arisen in the course of a hearing, or where the tribunal has asked a specific factual or legal question that may need to be answered. That's what happens, for example, at the ICJ and the European Court of Human Rights and the European Court of Justice, and in English courts, the courts that I know. Yet in many cases in which I have sat, the post-hearing brief simply serves as a kind of third-round rehash of all the facts and all the legal arguments, and sometimes it can morph into 2 or 3 rounds of post-hearing briefs, hundreds of pages, adding 1 million or more to the costs. Such documents are, in my experience, almost always of limited, if any, assistance to an attentive arbitrator who is well prepared and who, by the close of a hearing, will have begun to form a view on the documentary or testamentary evidence and on the legal issues. Yet these creatures allow hundreds more hours to be billed and further delay to be caused. They are, in my view, more often than not, a complete waste of time and effort and utterly useless. What other system has a post-hearing brief? None. No one else has it, as far as I'm aware. Not at the national level, not at the international level, not the ICJ, not ITLOS, not the ECJ, not the ECHR, not the trade system. No one has it. In cases before all these courts and tribunals, the adjudicators get by just fine without all the extra paper. So we have to ask, is investment arbitration qualitatively more complex or different? It is not. The practice appears to be driven by lawyers, but it is one which we arbitrators are complicit in because of our excess of deference. The post-hearing brief, indeed, is a creature that reflects a culture of excessive deference, constructed on a premise of excess, of cases and of costs. Why do we have to be so deferential? It's often said that we should heed the parties' wishes, or at least the wishes of their lawyers, because the parties themselves are often clueless as to what the lawyers are actually asking for. And the suspicion is that the party very often actually has no view on the matter. Is this linked, in some cases at least, to the desire on the part of the arbitrators to avoid a behaviour that could limit the possibility of future appointments? Everyone in the room knows what I am saying. And that brings me to the subject of third-party funding. Now, this, we all know, and I know, is a most delicate matter. For reasons of which you are aware, some of you, I will be extremely careful what I say about this subject matter. I thought, of course, of not saying anything at all, but I am a believer in free expression. I was the chair of English Pen, and I believe that reasonable expression is important and that judges and arbitrators are not required to curtail it entirely, although some might think otherwise. Third-party funding involves entities with no involvement in the underlying investment or any particular expertise to assist the parties or the tribunal. It provides a claimant with funding to litigate a case in return for which, if the claim is successful, it might receive a healthy fee that could include a significant proportion of any damages awarded. Funding agreements may even give the funder input into a case, including the choice of an arbitrator or counsel, or the terms under which a case might be settled, or other aspects. In most cases, despite this active involvement and interest in the outcome, a tribunal has no power to make a costs award against a third-party funder. This gives rise to what has been referred to as a gambler's nirvana, in which the third-party funder is able to speculate on the outcome of a case, or 10 cases, if it wishes to invest in 10 or more, without bearing the full risk of failure. Indeed, if you are a hedge fund, you may invest in a whole bundle of cases and only need to hit the jackpot in one in order to make the entire enterprise financially worthwhile. The rationale is said to be access to justice. It is said that without third-party funding, some parties may not be able to bring a case at all. Now, in some situations, this is plainly true, and that a very legitimate argument can be made for allowing an impecunious claimant who would not otherwise be able to do so to bring a case. And I've sat on a number of such cases and have found for a claimant who is so assisted, and I have no difficulty in so funding. But there are other cases that one encounters in which a claimant plainly is able to pay significant costs, which are then topped up as or more significantly by a third-party funder. I'm not alone in having expressed concerns at certain arrangement, particularly where the third-party funder isn't exposed to any cost risks. The arrangements may be said to assist in delivering a flowering of sorts. Even bigger fees for the lawyers, even more cases for the arbitrators, and a deeper, wider, and more lucrative trough into which all of our snouts may be dipped. And that is bothersome. That appeared to be the case in Echo Oro versus Columbia. It was one of the factors that caused me to write a separate declaration on costs, the one I've mentioned. The claimant requested in that case that it be reimbursed for, quote, a portion of the costs that it had no option to incur, but to incur to obtain financing to enable it to pursue the arbitration. That amount was around $4.5 million to get access to the funds. The tribunal declined to make any costs order in favour of the claimant, so that claim fell away. But in my mind, the wording of the matter raised issues concerning the financing of the proceedings, including by third parties. I wrote, and I quote, the claimant asserted that, quote, absent financing from third parties, it would have had no means to bring its claim against Columbia, end of quote. And then I continue. In this case, the third-party funding included financial support in the amount of an investment in the claimant of $14 million provided by TREXS Investments, an entity managed by Tenor Capital Management Company. This investment entitled the investor to up to 51% of the gross proceeds of the arbitration. End of quote. I then continued, and I quote, "Third-party funding is said by some to have an important role in ensuring that parties of limited means are able to pursue claims and vindicate their rights. That may be true in some cases, but in my view, that justification cannot be invoked in this one. I have the most serious concerns regarding such arrangements. The overriding purpose of investor-state proceedings is to allow claimants to bring claims and recover losses when the host state has breached its investment obligations. Yet there is a real risk of that purpose being subverted when claims are controlled or directed by a third-party funder which has no prior relationship with the purported investment or the host state. The risk is even greater when the third-party funder is entitled to recover a significant proportion or even a majority of any damages awarded by a tribunal and is not required to contribute to the costs of the opposing party if the claim fails." End of quote. I then cited from a passage from Dr. Kamal Hussein's dissenting opinion in Tenver versus Argentina, in which he wrote that the BIT in that case was not intended to enable payments of awards to third-party funders who are not investors and who have no protected investment and who only come into the dispute to advance funds in order to speculate on the outcome of a pending arbitration. In my declaration on costs, I noted and welcomed moves towards greater transparency and consideration by an UNCITRAL working group, but expressed the view that these initiatives may well be too little, too late. And I wrote as follows: "The current inability of tribunals to make costs awards against third-party funders is a real and serious issue and has attracted the concern of arbitrators in previous cases. In my view, the creation of a gambler's nirvana by allowing third-party funders to use investor-state dispute settlement as a means of financial speculation without any possibility of making costs awards against those funders is deeply problematic. Such funders may be closely engaged in the conduct of the proceedings, which can be burdensome, time-consuming, and sensitive. Their involvement may add to the costs of those proceedings. For that reason, as a matter of principle, a tribunal should be able to make a costs order against a third-party funder. Nor do I see any reason as a matter of principle why a successful party should not be able to bring legal proceedings in such fora as may be available at the national or international level to recover its costs from a third-party funder that has contributed to significant expenses being incurred in unsuccessful claims. Such approaches are increasingly finding favour with domestic courts and with individual arbitral institutions." End of quote. Now, we all know that anything you write is liable to have consequences, and these words did indeed have consequences. They caused me to be challenged in another case in which a third-party funder was involved. It was said that my words were an attack on third-party funding and that they demonstrated an appearance of bias or predisposition against parties with such funding and the appearance of prejudgment of issues likely to be relevant in the new case that had been filed. And this, it was said, as part of the challenge, gave rise to justifiable doubts as to my impartiality and independence. The proposal to disqualify was considered by the two other arbitrators who rejected it. They did so on the basis that a reasonable third party would not consider that the declaration on costs that I had written exhibited bias or appearance of bias against the claimant in the new case, or give rise to justifiable doubts as to independence or impartiality. That decision has been reported, is available to all of you to read. I leave it to you to do so, if you wish to do so, to form a view as to the reasoning and the implications on matters of substance and on an arbitrator's ability to express views in a declaration of that kind. And since the case is pending, I will express no views on the decision. I would merely wish to make clear, however, that a party is fully entitled to make such a challenge, just as a judge in a domestic or international case could be challenged, and an arbitrator or a judge, as in a domestic or other international case, must be able to express views on issues relating to the administration of justice in regard to the system in which they sit. The nature of the arbitral system and of the function of arbitrators are, in my view, as you will have heard this evening, matters on which much more needs to be said. And that's the purpose of this lecture. I want to provoke a reaction. On which note, I have to say something about the community of arbitrators, of which I am a part. In many cases, it is a real pleasure and a decent professional experience to sit with fellow arbitrators. They are often individuals who approach their work with a true sense of dedication, public service, rigor, independence, and integrity. They are, in such situations, individuals with a fully open mind as to the facts and the law. But it is less of a pleasure to sit with colleagues who are, how shall I put this, less collegial or willing to engage in a real exchange in which you encounter a mind that is closed. And that happens not infrequently. Now, of course, in any community, there are going to be a range of views, and diversity is important in enhancing the legitimacy of any system. A broad church is generally a good thing. It's also the case that arbitrators are human beings. They have predispositions. I have predispositions, as I've already explained. For example, in relation to a desire to respect the rules of international law that have actually been drafted, negotiated, and adopted, or to ensure that the practical realities of the environmental challenges that we currently face are, in some way at least, taken into account. And some of the most impressive arbitrators I've sat with are actually drawn from a world of commercial law with no prior engagement in the world of public international law. Their ability to engage with a treaty is second to none. They are as independent, impartial, and open as anyone else. I've come to the view, too, that the move to some greater degree of gender diversity has been incredibly positive in the field of investor-state arbitration. I've mentioned this already in passing. I am partial to a thesis expressed by Carol Gilligan. The title of her book says it all, in a different voice, which I read back in 1984 when I heard her lecture at Harvard. But as I mentioned, for the first 12 years of my life as an arbitrator, I only sat on all-male panels. Then came a first case with a female arbitrator, then another, then a case with 2 female arbitrators, in which I was the only male. And I have to say, in general, I have found it to be a different experience. It has been more collegial and more consensual. It has been less prone to the fractured insecurities that seem to be attached to so many male egos, that toxic combination of vulnerability, status, and competitiveness, to which I, no doubt, am also partial. But diversity remains incredibly limited. I've sat in more than 70 investment arbitration cases. How can it be that I've never sat with a person who is black? A few years ago, Judge Abdulaki Yusuf delivered a lecture at my university in London, at UCL, in which he made the point that while 25% of ICSID cases involved African countries, less than 2% of such cases involved African arbitrators. This is a real issue. And we have to talk about it, and we have to confront it, because it goes to the legitimacy of the system. As with the very limited range of counsel who appear before these cases, I've never had an African law firm appear before me in any case. A system that lacks representativeness is a system that lacks legitimacy, and a system that lacks legitimacy is doomed. Who we sit with, how we engage with those we sit with, is increasingly a matter I think about and worry about. Life is short. I want to sit with colleagues who are broadly representative of the communities the system of investor-state arbitration is intended to serve. That includes states, companies, and people from around the whole world, not just a part of it. I want to sit with colleagues for whom serving as an arbitrator is driven, to some degree at least, by a sense of public service, not a desire to enhance personal esteem or worth or income. I don't want to be part of a business. We arbitrators are very handsomely paid. Many reasonable observers would say far, far too handsomely. Our daily per diem, just food, hotel, travel, taxis or whatever, at ICSID, part of the World Bank family, is $900 US. That's just the per diem. That is 4 times the average annual income of every person in Burundi. Think about it for a moment within the World Bank family. And if you want to get a sense of life in Burundi, read Gail Fay's remarkable novel, Small Country, or the one that has just been up for the Prix Goncourt, Jacaranda. And this is just the per diem. It's not the daily rate of about $4,000 US, more than the average total annual income of every person in Egypt. Beyond that, as an arbitrator, I don't want to be instrumentalized as part of a system which is primarily becoming the generation of a certain lifestyle for lawyers and law firms, for experts and arbitrators, and for third-party funders. And so what this means in practice for me is that I've become increasingly picky as to the cases on which I will sit. I limit the number of cases to no more than 12 at any one time. I want to be able to attend to them properly, and that's why I turn down the vast majority of inquiries about appointments. But it's not the only reason I turn them down. There are some colleagues, very frankly, I do not wish to sit with, where minds are closed, where there will be no genuine and open exchange and deliberation. So let me draw together the threads. I've touched on various matters, including costs and procedures and matters of substance, the environment, for example. Separately and together, these and other issues are increasingly giving rise to doubts about my own future engagement with a system that sprung to life in the 1960s, one that was established with the best of intentions, but which has, I think, taken a more dubious turn. This is a matter of personal discomfort. This is a matter of personal discontent, which I expressed this evening whilst fully respecting the expression of alternative views. To a degree, that discontent is reflected in what I've written in the Declaration on Costs. I thought very carefully about writing that declaration, and I wrote it with care, particularly in relation to its tone as well as its content. I wrote it as an expression of hope for the future well-being of a system of which I am a part. I often think back to those early days and the good intentions and values of decent folk like Ronnie Brokers, who I met so early in my career. What I wrote in the last paragraph on that Declaration on Costs is as follows. Arbitration proceedings of this kind are a form of privatized justice. The proceedings can be costly, especially when there is a need for specialist knowledge. Yet it's surely incumbent on all involved in the system to keep in mind its original and aspirational mandate, to offer an effective and fair system to resolve serious disputes between foreign investors and host states in a manner that is efficient, cost-effective, and consistent with rules agreed by states. Those who designed it and put it in place had good intentions. It was not envisaged to be a system to leverage financial speculation and financial gains by third parties. A case such as Echo Oro, incurring vast financial and human resource costs, and which could not have been brought without the support of a third-party funder, will, I fear, serve to undermine confidence in an important system and foster perceptions that it lacks essential legitimacy, and will, without further fundamental reform, soon take the path of investor-state arbitration under the NAFTA and the Energy Charter Treaty. End of quote. The warning signs are there for everybody. There is more attention to this subject, there is more noise, and there is far, far more critique. Of course, we can choose to ignore it, but would that be wise? I think it is better to engage. And we have to recognize, in short, that investor-state arbitration is increasingly seen as a business with a lack of legitimacy. I've shared my own sense of increasing discomfort at aspects of my own involvement. What began in an age of innocence segued into and beyond into an age of experience and has now moved into an age of discontent. I stand by the awards and declarations and dissents I've written, but I find it increasingly difficult to put my hand on my heart and say to you, this is a system I feel proud to be a part of. Increasingly, I worry that I'm part of something that actually doesn't enhance the well-being of human beings or countries. Is there actually any evidence, real evidence, that investor-state arbitration actually enhances flows of direct foreign investment or the per capita income of the poorest sectors of society? I don't think there is. Increasingly, I also worry whether this system contributes to a broader rule of law ethic or actually, and possibly more likely, undermines it by imposing a lopsided set of obligations often invoked to undermine legitimate actions that are far removed from the original intentions of the system's first proponents, and in so doing, privilege certain actors, including myself. I feel that I have become a part of that business, where the principal beneficiaries, measurably, are the lawyers and the law firms, the arbitrators and experts, the third-party funders, the conference organisers, the publishers, who've barnacled themselves onto a growing and monstrous cash cow, and who, if they do not exercise some degree of self-restraint, are going to push the entire system over the edge. Maybe that will be a good thing, maybe not. Will the disappearance of the NAFTA chapter and the Energy Charter Treaty actually diminish any cross-border investments? I've not seen any evidence that they will. Yet I have not yet bailed, because I entertain some vague hope that the original rationale may not be entirely misguided. That's why I write these declarations or dissents. That's why I'm standing before you tonight. Declarations and dissents that I write to be read not only by the most direct addressees, the parties to the proceedings, but also by others who might read these things. And in this way, in a certain sense, the cases about the Paramos could be seen by some as offering a smidgen of hope, that it might yet be possible for the system to deliver on its original intentions by offering recourse where it is genuinely needed, but also allowing states to take actions necessary to protect the collective good. I'd love to be able to say that I truly respect the attempts at reform or the intentions of some of those who promote them, but the truth is I'm pretty sceptical. They offer the illusion of change. But on the key issues, is anything really going to change? Delay, costs, double hatting, plus ça change, etc., etc. In short, I've come to the view that the heart of the problem is actually the ad hoc, private, arbitral system. It may work for purely commercial or private matters, but it is ill-suited to the resolution of disputes imbued with some public element. And over the longer term, I suspect that the only way to preserve a sense of the broader legitimacy of the system, if indeed it is needed at all, which I and others increasingly doubt, the most likely route would be a standing investment court comprised of permanent judges. This would bring to an end the culture of arbitral deference and revolving doors, one that is sometimes imbued with cronyism of a particular kind, where those charged with deciding a case might do so in the knowledge that if they opt for a particular outcome, they may be liable to have more cases in the future. A court model gets rid of that completely, with security of tenor. And a court model would also allow for the development of a more coherent and principled body of law, a move away from the lottery which very frankly currently exists, where the outcome quite often turns on who happens to be the presiding arbitrator. But of course, such a system with a court would be far less profitable. Arbitrators' fees would collapse, and the ginormous fees increasingly charged by certain litigators would become untenable because judges are simply not going to tolerate them, and because the judges will be more likely to rein in the excesses of certain procedures. The post-hearing brief would disappear. Discovery processes would be tempered. Hopeless cross-examination would be shut down. Third-party funding would be regulated, and so on. And we all know where the opposition to reforms of that kind comes from. No one can plausibly deny the crisis which international investment law now finds itself in. I'm not the first, and I will not be the last, to identify aspects of the many problems. And one of my favorite law books remains the sociologist Yves Désollé's brilliant book, you only need to mention the title to get a sense of it, Dealing in Virtue. If this field is to have a future, each of us, myself included, has to take a long, hard look at ourselves and reflect on whether our work is a positive contribution to the development of a principled and effective system. We can no longer assume that others will fix this system for us. It is for each of us to reflect about the day-to-day decisions we make in the course of arguing and deciding cases. And that requires a broad and honest debate, which is the purpose of my giving this lecture, for which I express real thanks. And it requires, frankly, a generational shift in which lawyers, arbitrators, and experts recognize that the purpose of investment law is not to provide them with gainful employment. The students among you this evening are my most important audience. You are the ones who have the power in the longer run to change this system. By all means, go out and work for one of the law firms and earn bucket loads of money coming straight out of law school. But ask yourself this question. Can you put your hand on your heart and say, you really feel good about yourself and what you are doing? These are hard questions, they're tough questions, and we have to be honest in raising them and addressing them. For the lawyers, one might ask, are these levels of fees really justifiable? Are there limits to the arguments I'm prepared to advance? Are my decisions taken in the best interests of the client or for my own financial benefit, or that of the partners for whom I am serving? For the arbitrators, the questions might be, am I doing this for public service, or to make a profitable living, or to enhance my own sense of worth and purpose? Am I willing to turn down appointments in order to pay sufficient attention to my caseload? Are my decisions based on my views of the law and the facts, or are they premised on my hope or desire for future appointments? For the experts, am I involved to serve the interests of the party that has appointed me, or to assist the tribunal? Can I really justify the level of damages that I have come up with? Can I really justify how much I'm charging for the pieces of paper I'm writing? And for the third-party funders, does the case I'm funding actually have any real prospect of success? And if it does, why aren't I willing to bear the risk of contributing to the other side's costs if I'm wrong on that? And is my contribution really needed to be able to bring a case? There are, of course, a whole host of other questions that could be asked. Let's ask them. Let's not be frightened to raise them and to address them openly and honestly and recognizing there's a broad range of views. Let's have a public debate about these issues. If we don't have a public debate, if we don't engage with these issues, the path forward is crystal clear. It's the path of the NAFTA investment chapter, it's the path of the Energy Charter Treaty investment chapter, it's the path going forward. During my career, 40 years doing this stuff, the system has drifted away from the spirit of public service embodied by characters like Ronnie Brocas, the Lalive brothers, and James Crawford. And increasingly, it does seem to serve financial and psychological aspirations and needs of many of those involved. Of course, not all, and probably not even a majority. But if investor-state dispute settlement is to be able to deal with the challenges of the future, it's going to have to be seen as legitimate. And for that, it needs to regain a sense of public service, of balance, of decency, and of reasonableness on procedures, on substance, and on costs. Thank you very much for your attention. Hey, now the fun begins.
Thank you so much, Philippe. That was really brilliant. Lots of discomfort, I think you've created, for some at least here. Kind of brought expression to some of the discomforts I've always had but never been able to verbalize. So kind of I think that's really, really fantastic. Thank you so much for taking us through this journey, through the depths and details, as well as the big questions. So kind of really, really great. I think we have a kind of a short amount of time for some questions, and it would be nice kind of to take maybe 3 or so for now, and then we take it from there, and you kind of answer as you like. Who would like to start? Please identify yourself first, and then so we start with Nart. Here. Well, yeah. So
please don't be scared to ask.
We take that group there on the front. Yeah, thanks, Ruth.
Me and it's all healthy.
I'm not sure if I'll be able to provide a criticism, but my name is Nart. I'm a second-year Master in International Law student. If it's of any comfort, I definitely will certify the fact that disillusionment with the system is not a fringe opinion among my classmates, hopefully. But I just want to ask, since you mentioned the shift from the origins of a rules-based legal order for the protection of foreign investments to a money-making machine today, do you know, or do you have any perception of a catalyst or a historical instance or a shift in ideological motives that led to this, or was it just a natural form of shift? Thank you. Oh, and just a very short technical question. What was the name of the case that you mentioned? The Nord Stream, I think, about the... Sorry, 1 second. Justifiable doubts as to your impartiality that were raised? Just to check the name of the case, sorry.
It's public, so that's Silver Bull versus Mexico. It's public, so you can read that. It's on the ICSID website. The decision's on the website. I'll come back to the questions. Let's
group them together. Yes.
Thank you, Professor Sands. My name's Harshad. I'm an ISDS lawyer, but also doing my PhD in Geneva. My question's more pedantic, I would say, in comparison. You mentioned the Bear Creek decision in 2017, where, at least on the merits, you agreed with the majority, even though there were a lot of social interest and cultural rights questions involved. If we come to 2024, earlier this year, Red Eagle, where, again, with the majority, but if I remember the award correctly, wrote something on the lines of, as long as the tribunal has, as long as the state has a legitimate purpose, the tribunal has no business questioning how the state balances environment and property, which I read it as contrasting to what the majority with which you agreed in Bear Creek. So my question is, hand on heart, did something change between 2017, 24, and if yes, what it may be? Thank you.
Okay. I have a question from a remote participant, Adam Samuels. Personally, I'm glad I heard your lecture now and not 30 years ago. Might be in another job now. How is this going to be organized? A rewrite of the Washington Convention and the associated rules, the removal of arbitration provisions from the BITs? I think it's a practical question.
Thank you. Let's take one more. Maybe. Okay. Well, we have two more. Okay, Catherine.
Thanks very much. My name's Catherine, and I'm a first-year Master in International Law student. I'm also asking a question that sort of zooms out again from the detail, and it's quite similar, I think, to the question that my first colleague raised, which is sort of linking two things that you said, the first being that these investment treaties started as a way of direct foreign investment in developing countries and so on, and then moving to the state we have now, where states are pulling out of the Energy Charter Treaty or trying to exempt themselves from sort of investment state clauses in regional trade agreements, or not signing new bilateral trade agreements, investment agreements, sorry. I was just wondering if you have seen in your decades of experience a trend in who is the complainant and who is the respondent in these treaties, and whether there's sort of anything to say about a trend in that area and your reflections on it. Thank you.
Thanks. Let's take one more.
Hi, Professor. Thank you. That was very interesting.
You need to stand up because I can't see where it's coming from.
Sorry.
Okay, great. Thanks.
Thank you. I really enjoyed the lecture. My name is Saheli. I'm a student at the University of Bern, but I'm interning at the Center for International Environmental Law. My question is sort of about what your perception of the involvement of amicus curiae and third parties and sort of their influence and broader civil society, and how in investment arbitration. Thank you.
So I think you have a broad menu of questions.
Yeah. So the first question, so the case that is on the ICSID website, so you can see is Silver Bull versus Mexico, and it's publicly available. What was the catalyst? I mean, obviously that's a very big and complex question, and I'm simply giving an instinctual response. But I think that the move that has occurred is that in the early days of the life of investor-state arbitration, the lawyers who were involved tended to come from an academic background, or if they were associated with a law firm, they were solo or just a tiny small group of practitioners. And I think, but others may disagree, is that the way the change has happened is that the larger law firms have entered the fray and come to see this as a highly lucrative area to develop practice. And you see that articulated, for example, in the cases, and I've written about this elsewhere, where you'll literally get, in some cases, 25 lawyers turning up on one side of the table, and the other side of the table there'll be 3 people. And you're looking as an arbitrator, and whenever I did cases, we were only ever 2 or 3 people. These cases simply do not need 25 people. I've never had a case as counsel that needs 25 people, or really more than 3 or 4 people, to be honest. And you look down the table, and you see 25 lovely faces. You don't really know what they're doing. At no point do they actually engage with you. The argument is limited to a very small number of people. They're often on their phones or BlackBerries. And my instinct is that it is the answer to your question resides in the nature of certain law firms. Now, it is definitely not all law firms, because there are some law firms, you often get cases where, the mega London, New York, I hesitate to say Geneva, but Paris firms are not involved. They're small firms, and they turn up, you've never heard of them, and they turn up and they do it with 2 or 3 people, and they do it brilliantly well. So it's basically in the business of law that the change has happened. And these mega firms paying mega bucks to my students who come straight out of law school and are earning $200,000 a year, and really you're asking yourself the question, on what basis is that kind of money justified for what they're actually doing? And then those folks, often my students, turn up in the hearings and you sort of say, well, what are you sort of actually doing? And they'll mumble and not really tell you what they're actually doing. But I think that is where the issue has arisen. And it's in the structures of those law firms, which of course are built on a particular hierarchy in which certain people at the top earn really mega sums, and to justify those sums, you've got to find gainful employment for people further down. But the bottom line of it is, these cases are really not complicated very often. The issues are always the same. You don't need pleadings of 400 pages, 500 pages, and the pleadings are really often repetitive, not good. We've all of us who sit as arbitrators seen cuts and pastes where someone takes 200 pages of arguments on something from one case and then it reappears in another case, and you then see the costs at the end and you just ask yourself, well, what's actually happened? I think that is the source of the difficulty. In relation to Bear Creek, no, my view hasn't changed. I think it's the difference of the two cases. What had happened in the Bear Creek case, and I've written this in my partial dissent, and the reason that I joined with the majority, with a unanimous decision on the violation, was that the government at that time simply took a decision without giving the claimant an opportunity to address the issues in advance. It was just, an instant decision that was taken. So you could not say that was reasonable decision-making in the circumstances. Whereas in the Paramos case, anyone who's read those cases knows that the government of Colombia, it's not a perfect decision-making, but any government is pulled in all sorts of directions. Different parties are going in different directions. One ministry wants one thing, another ministry wants another thing. And so governments are struggling to take decisions where issues are contested. And I think in those circumstances, there needs to be some wiggle room to recognize that these are difficult decisions to take, and that if they are taken imperfectly, it's not appropriate to punish, provided the imperfection doesn't cross a particular line of egregiousness. And in the Paramos cases, I didn't think that it had crossed such a line. So my view has been, I hope, consistent all along. Adam Samuel's question, how is it going to change? One of the things that has interested me in the last 15 years is that it does actually make a difference to be talking about things and talking about them openly and honestly, even if there are a wide range of views. When I was first instructed in the Chagos case, in 2010, I was sent by the then government of Mauritius, headed by the person who's just become Prime Minister again, Mr. Ramgoolam, to Washington to meet the Secretary of State's office. And I've put this in my book, Last Colony, so I'm not disclosing anything that's not public. It was publicly available at the time, to basically assure the State Department that by bringing proceedings against the United Kingdom in relation to the illegal occupation of Chagos, Mauritius was committed to the long-term presence of the military base at Diego Garcia. And I won't soon forget the response that we were given by the very distinguished legal advisor at the time, who some people in the room will have worked out who it was. who told us that our arguments on this were complete crap, they would go nowhere, it was useless, that no one would find jurisdiction, it was hopeless. And of course, over time, things took a different turn. And the publication of the book, The Last Colony, I think, had an impact, just as the publication of books like East-West Street have had an impact on people's thinkings about concepts like crimes against humanity and genocide. And so my hope would be that change can be effected through a non-revolutionary process, that is to say, through talking and amendment. But I'm, as I said, a little bit skeptical about that. There are not many decisions taken by Donald Trump that I support, but one of them was to close down the NAFTA investment chapter, which has had zero impact on flows of investment between and among those three countries, living proof that it has really changed absolutely nothing, apart from the well-being of arbitrators like me and lawyers who get involved and experts who get involved and third-party funders who get involved in these kinds of cases. So I think the answer to Adam's question is we've got to start talking about it, and we've got to start talking about it a lot more honestly, and we've got to start talking about it outside of our community. You have to reach a broader audience, and the way to do that is by pieces in the New Yorker magazine, pieces in the newspapers, books that actually tell stories, and people start to get energized about it. But the fundamental issue, I think, to think about is, do we actually need this system at all? I haven't concluded that we don't, but I have certain doubts in relation to the evidence as to whether a bilateral treaty or a series of bilateral treaties actually changes flows of direct foreign investment in any ways at all. My brother-in-law, who is a Nobel Prize-winning economist called Joseph Stiglitz, and with whom I talk about a lot these issues, says there is no evidence whatsoever that bilateral investment treaties or investment chapters alter flows of direct foreign investment in any way. And I've got to say, I find it really hard to get that claim out of my mind. I look at South America, and I see that the only country in South America that has not a single bilateral investment treaty and has never accepted investor-state arbitration, Brazil, has more direct foreign investment than anyone else. So we really do have to engage with that reality in asking ourselves what it is that we're doing and how do we justify what we are doing. Catherine, I didn't fully, I think, understand the question on trends in relation to complainants and respondents, but even if I had, I think I would not be able to give you answers that are not drawn from my own direct experience in terms of the negotiations of these instruments. I mean, one of the things that has surprised me and that I'm sort of turning my mind to is why it is more states have not bailed from these kinds of arrangements. And I think the answer to that probably lies in the fact that there is another revolving door that never gets talked about, and it's the revolving door between the very badly paid government legal advisor in many countries around the world and the law firm that comes along and says, actually, in a couple of years, you can make the shift and you can come and work for us. And that lawyer, and I know this anecdotally, in the government legal system, is often the person to whom a minister will turn for advice on whether or not they should proceed in so-and-so direction. And put yourself in the position of that individual. We've seen the revolving doors between government legal service or indeed also the secretariats and the law firms in terms of directions of career directories. I mean, in relation to amicus curiae, I'm, in the right circumstances, I think it is extremely important that stakeholders who are genuinely and directly interested in a project should have an opportunity to contribute to the gaps that may exist in the knowledge of the arbitrators on the significance, the relevance, the facts of a particular project. That question ultimately goes to the issue of the legitimacy of the system. To close the door completely to such actors risks delegitimizing the system. To open the door too widely to those kinds of interests risks overwhelming the system. And so a balance has to be found. And I think from my own experience, the critical issue in dealing with a request for an amicus intervention is the answer to the question, will this particular person or group be able to address issues that are directly relevant in these proceedings, are not being addressed by anyone else, and can help build up our factual base and our assessment of the law in a way that would not otherwise be done. And that is going to be a pretty limited cast of characters, but it leaves the door open in the right circumstances.
It used to be on. Whatever. My voice carries, I think. Thank you so much. I think we could take many more questions. I have about 17 kind of written down. I'm not going to bother you with those because we have some drinks waiting upstairs and we should get to them. But let me thank you really kind of for kind of a lecture and answers to questions that kind of bring together sort of engagement with the law and kind of obviously passionate engagement with the law, but with a kind of a broader purpose also that I think in many ways succeeds in sort of making us question some of the fundamental beliefs that we have that somehow more law is always merrier, more judicialization is always merrier, but that really kind of the devil is in how that law evolves, what law it is, and who manages, and in a sense navigates and manipulates that kind of law. So thank you very much again, and I invite everybody on behalf of LaLive, who are thankfully sponsoring us, to have some drinks upstairs. Thank you.